Thank you, Jessica. So yes, I am Britt Berner, and although I do run our Manhattan office, I am sitting in our West Hampton Beach office right now. And that's the scene you see behind you. It's one of our offices. And yes, there's a big change coming. I am not one to deal with people or push people on fear and try and say, hurry up, act fast. You know, anyone who's met with me to talk about their situation or the situation for a loved one knows that I usually say, we're here whenever you're ready. These are the rules, and we're here whenever you're ready to do it. But we are in an act fast situation. And we wanted to have this session today, and we're going to be putting it up on our website like we do our other sessions, because it is important that people understand these changes that are happening and what that means for them. Very often people hear these terms, look back, penalty, Medicaid home care, nursing home care. What does all of that mean? And so what we are going to be talking about today is what it means and what it might mean for you or for your loved one, and why it might mean you need to act fast. So as many of you may know, if you've kept up on reading either stuff from our website or our newsletters or others, other attorneys or organizations, is that in April, the beginning of April, the budget was signed for the 2020 and 2021 fiscal year of New York State. And often what happens in the budget is that in cutting dollars, they change the laws for programming, that those laws make it so that less people qualify. That happened this year with Medicaid. And I'm not going to go into the whole background of how this happens in New York State and the budget and the Medicaid redesign team, although it's very interesting if you choose to read about it, and feel free to reach out and I can tell you a little more about it. But what ended up happening was that the laws, the social services law of the state was changed in a way that makes it more difficult for people to apply for the Medicaid program. By having less people be eligible to apply, the government feels that they're saving money, and that's why it's part of the budget process. So what does that actually mean, right? What changed? So all sorts of things changed, but today we're really going to be focusing on the eligibility requirements when we're talking about financial eligibility. We can talk separately, and I have done sessions where we talk about the changes to the medical and nursing assessments and all of that, but this is really talking about the fiscal changes here. So we have something called spousal refusal in New York State. That means that one spouse can have assets above and beyond that of the Medicaid spouse, and the Medicaid spouse can still qualify. That did not change. There was a proposal that be eliminated in New York, as it has been in most other states in the country, but we do still have spousal refusal here. That is a good thing. We also have remained where the spouse can have assets of up to $128,640. That's another thing that was a proposed change that has stayed. So we're still in a state that is saying that a spouse can keep assets in their name, and that's great. Those are good things. We're very happy about them. But the most significant financial change that is happening to Medicaid as a result of this budget, the changes in the budget, is a 2.5-year look back is being placed for community Medicaid or home care Medicaid. Now, what does that mean? So currently, the law says that there is no look back for home care Medicaid, but there is a 5-year look back for nursing home Medicaid. The difference is that for home care, if it's August 20th, as it is right now, if I have $100,000 in my name and I transfer it out of my name this month, today, as long as it's out of my name, cleared out of my name by close of business on August 31st, I can apply for home care Medicaid on September 1st with no penalty being assessed for the fact that I transferred those assets. The 5-year look back in the nursing home would assess a penalty for those transfers. So if I transferred, and the numbers of how the penalty is determined changes based on where you live. So for Long Island, where I'm sitting right now, Nassau and Suffolk counties, for every $13,407 you transfer out of your name within that 5 years, that's 60 months before going to the nursing home, it's a 1-month penalty. So if I transfer $27,000 out of my name this month, I'm going to end up with a 2-month penalty. 2 months that Medicaid won't pay for the cost of my care, and I need to cover the cost of my care on my own, which is often, especially on Long Island, more expensive than that $13,000 number. In New York City, the corresponding number is $12,844. So similarly, if I transfer $12,844 out of my name within the 5 years, I'm creating a 1-month penalty. Now, these are uncompensated transfers. They're gifts. This does not, if you buy yourself a car, if you take a trip around the world, not that we're doing that so much these days, but when we did, if you are buying yourself clothing, anything for your own benefit, there's not going to be an issue. But this is talking about uncompensated transfers. So if you give a $10,000 gift to your grandchild, if you go for that trip around the world, but you take a companion, you take a friend, and you pay for your friend's trip as well. These are all gifts that are uncompensated that can create that Medicaid penalty. And so we like to tell people that that penalty is a legal presumption. So you can say, well, I gave $10,000 to my grandchild, and Medicaid immediately says there is a legal presumption that you transferred that money so that you can make yourself impoverished and therefore eligible for Medicaid. And you may say, I didn't do it for that reason. I gave $10,000 to that grandchild because I had 10 others. And when those 10 other grandchildren got married, I gave them $10,000. And this was just the 11th one. And then that's an argument that you would have, and you would go to a hearing and you would prove that that wasn't why you were giving the money away. But there's a presumption there. And so it's something we have to deal with when people are applying for a nursing home. We've never had to deal with it with community Medicaid. We were lucky. Not the case anymore. As of October 1st, this new law states that transfers made after October 1st will be susceptible to a 2.5-year look back for home care Medicaid eligibility. So what does this really mean, right? What happens if I apply for Medicaid? What's the difference going to be? Well, the first difference is you're going to have to provide more documentation than you ever had to before. Now, if I had given this talk to you 2 months ago, maybe even a month and a half ago, I would have told you that that 2.5-year look back goes all the way back to 2008. Meaning if I applied on November 1 of this year for Medicaid, I would go back and they'd be looking at the 2.5 years prior. We have since gotten clarification from the Department of Health, thank God, that all prior transfers prior to the October 1st, 2020 date will be grandfathered in. So if you transferred assets a month ago, or if you transfer assets between now and October 1st, those will not be brought into the 2.5-year look back. You won't have to worry about that. That's why we're in an act fast situation, and that's why we want people to be paying attention to what's going on, because it will have real consequences for you if you don't get the information that you need relatively soon. Now, I'm not saying everybody should move all the money out of their name in the next 2 months, but if you're someone who is thinking that this may be a program that you need to take advantage of sometime soon, you want to find out the information and how this applies in your specific situation. So with this new information we have about being grandfathered in, the good news is it's going to be a phased in process. This is what we hoped from the beginning. This is how the 5-year look back was phased in, and this is what we wanted. And if we have to put up with a look back, we at least want it to be something we can work with. So what that means is that on November 1st of 2020, there's a 1 month look back, because again, it can only go back to October 1. On December 1st, it's a 2 month look back. That's gonna grow all the way out until we hit June of 2023. That's when we hit 30 months, 2.5 years. And at that point, there'll be a full 2.5 year look back for applications beyond that point. So it won't always go back to October 1st, 2020. It'll just go back for 2.5 years. And just like with the nursing home situation, the Medicaid, the local district where you are, if you're outside of New York City, it's your local Department of Social Services. If you're inside New York City, it's the HRA, Human Resources Administration. You will have to submit this documentation to them and proof that you didn't make gifts within that time period. If you did make gifts, transfers, uncompensated within that time period, they will assess a penalty. The law has said that it will be the same calculation as for a nursing home. So that same $13,407 for Long Island, the same $12,844 for New York City. So again, this is a big change. This is something we never had to worry about before. It was, you're fine, hold on to your assets if you don't want to move them out of your name. Just the month before you need services, you're going to have to shift them. We're not going to have that benefit anymore. So certainly if you're a person who thinks that you may need Medicaid within the next 2.5 years and you have some assets that you want to transfer out of your name to protect, you're going to want to do that before October 1, 2020, so that you are not subject to that look back period. Another thing that we've found out that if I had talked to you a few months ago, I wouldn't have known, is that they have now delayed the start of this programming till January 1 of 2021. And the statute that was changed as part of the budget said that this delay could be put in place by the director of budget with this delay. And so they have put the delay in place. Now, what does that mean, right? So if I apply on October 1 of 2020, there is technically a look back on gifts during that time period. Although they've told us that they're not actually going to make you submit additional documentation regarding those transfers until January 1. So I'll give you a scenario. It's December 15th of 2020, and I'm applying for home care services for Medicaid. There is technically a look back period. So there is a what will be eventually 30-month look back by December 15th. It will be a 2.5-month look back to go back to October 1. However, they will not be making you submit the bank statements to show what went backwards. So is there really a look back if nobody's looking back? The Department of Health's position is, yes, there is a look back and you should comply and you should not transfer assets after October 1 and then subsequently apply, even though they're not going to make you submit that documentation right away. Their position is you still shouldn't be doing it. Once January hits, if it's January 15th of 2021 and I'm applying for home care Medicaid, I will have to submit my financial information that goes back to October 1 of 2020 and prove that I didn't transfer assets that created a penalty during that time period. Are there any questions up until that point? I'm going to move on to a few other issues, but I just want to see if anyone has any questions. There is a Q&A at the bottom you can click on and you could write your answer in there and we'll read them. I'll give it a second. Yes.
I have a question. So if somebody makes a transfer now and does not apply for Medicaid before January 1st, but applies a year from now, how does that work?
So if they apply, they will only have to do a look back to October 1 of 2020. So if you transfer assets now, Those will not be subject to the look back since we have this subsequent information about it being phased in. And so it will not create a penalty for Medicaid purposes as long as those transfers were done before October 1 of 2020. I see somebody has their hand raised. If that person could write the Q&A in at the bottom of the page, I think that would be helpful if you see that where that goes. The question was, does the transfer have to be cash? No, this could be the transfer of any assets. That's a good question. So this person that I'm talking about with $100,000, they could have $100,000 in checking and savings. That would be cash, so you would transfer that. It could be $100,000 worth of investments. It might be a rental property worth $100,000 that they're putting into a trust. The transfer can be to a person, to several people. It can be to certain trusts that qualify for exemption under Medicaid purposes. So this is any transfer of assets out of your name to another person or entity. And that is what we're referring to. Okay, I think that's it for the questions now. I'm going to move on, but if you have any question that pops in your head about something we've already discussed, feel free to write it in and we'll continue to answer the questions as we go on. So there are a few question marks that still exist with this transfer penalty. And some of these things, I was just on a call today and we're expecting to have another call with the Department of Health in September. When I say we, I'm talking about members of the New York State Bar Association Elder Law section. We lobbied on these issues before the budget came out, and we've also been in contact with the Department of Health since they came out by writings, as well as by writing memos to them, as well as on telephone calls. We're hoping to have another phone communication in September to gain further clarity. One of the really big questions is, when can you apply? What would be the start date for your penalty? So let me explain why this might be an issue. If you go to a nursing home and you go in under Medicare and your Medicare stops paying and you now have no payment source for that facility, that is what we call being otherwise eligible. So that is saying otherwise, meaning other than the financial determinations. You're eligible because you're in a facility and you do not have the payment source, the insurance source to pay for your care anymore. On that date, it is now clear that that's the date that you need Medicaid to pick up. This is a terminology we use in Medicaid language. It's the pickup date. It's the date that you need Medicaid to start covering. Once you pass that pickup date, that otherwise eligible date, you can apply for Medicaid because your assets have been brought below the level that's necessary, and you are otherwise eligible, meaning you're in a facility receiving services that Medicaid should be paying for. The problem, and I should add, in that circumstance, that facility waits for Medicaid to pay them. So if it takes 4 months for Medicaid to look through your application, that facility is waiting that amount of time, and once the approval comes in, then they will get a retroactive payment. But we don't have that luxury with home care. We don't have home care agencies right now. Maybe it'll change, but I don't know how the home care industry could support this. We don't have home care agencies that are willing to wait that 4 months to get paid. So are you ever going to be otherwise eligible if you're never in a position where you're receiving services that Medicaid should be paying for because you've spent your money down so you don't have the money to pay for those services? So you should feel like you're on a merry-go-round right now. There's this argument is circular. And so if we can't get out of that circle, how do we ever become Medicaid eligible and start, if you did transfer assets, start that penalty period? And this is something we've talked to the Department of Health about, and we're trying to get more information. Another, you know what, I think, do we have another question, Jessica?
We do. Somebody asked for clarification whether a transfer into an irrevocable trust after October 1st is subject to the look back
Oh, good question. So yes, that is a transfer. Remember, it's any time that I'm giving something away and I'm losing control of that asset, I'm creating a transfer that could give a penalty. So that's a perfect example. So if you want to transfer an investment account into an irrevocable Medicaid qualifying trust, yes, after October 1st, that is going to create a penalty. That's exactly the kind of transfer that we're referring to here. I would normally be using the home as an example of a transfer, but there's a lot of back and forth. This is one of the other question marks I was going to go over as to how the home is going to be considered in terms of transferring your home to an irrevocable trust. There's a strong argument out there that if it's an exempt asset for home care Medicaid because it's exempt because you're living in it, then how could there be a penalty for transferring an exempt asset to a trust? And so that's another one of those things that we're seeking clarification from the program on. But again, if you're looking for possibly receiving these services sometime soon, you're probably going to want to see an attorney and see if it makes sense for you to start making these transfers now. Another question mark that we're really hoping to resolve, and it seems like the Department of Health is working with us to resolve, is regarding pooled income trusts. So quick primer on a pooled income trust. These are trusts that accept an individual's excess income on a monthly basis that allows them to receive Medicaid services. So I'll give an example. If somebody has $1,895 worth of income, and income is going to include Social Security, pensions, required minimum distributions from your retirement accounts, interest income if you have investments, even some of those investments that are in trusts, you still receive the interest or the dividends. These are all sources of income. If you have a rental property and you receive rent from a tenant, that's going to count as income. We add all that up. Let's say it's $1,895. Medicaid says $895 is an allowable amount of income. Anything above that is excess. And you can do two things with excess income. One is you can give it to Medicaid. Now, I don't know very many people that can live in the community on Long Island or in New York City with only $895 worth of income. So it's very hard for people to say, I will take everything over $895 and I will give it to Medicaid and they'll provide me with care and that makes me happy. Because they have trouble meeting their daily bills if that's the case. The other thing that you can do with your excess income is put it into a pooled income trust. This is a type of trust that is owned by or run by a charity that is a supplemental needs trust. So it, under federal law, is created to supplement, not supplant, government benefits. So it's meant to be in addition to your government benefits. The upside is that if you take your assets and you put them in the pooled income trust on a monthly basis, you can then use them to pay your bills. The downside is that anything that accumulates over time, even though it rolls over month to month and it continues to accumulate, at the time of your death, whatever is left in the trust goes to the charity that runs the trust. This is really important to realize. So you've got income every month. Income is not an issue for Medicaid as long as it goes in the pool trust and presumably you use it. The problem with the new law is that if income goes into the pool trust, to the extent that you use it, that is a compensated transfer. I took my $1,000 worth of income, I transferred it to the trust, but it doesn't create a penalty because I used it and therefore it was compensated. The problem comes in if I transfer my money to the trust, I don't use all of it, and then now it's building up and accumulating. Have I now made an uncompensated transfer that should trigger a penalty for Medicaid? And again, these are one of those question marks that we're really looking into and we're speaking to the Department of Health about Because many people will put assets into their, or put income into their pooled income trust, and they allow it to accumulate over the course of a few months because maybe they pay their property taxes twice a year. So they want the money to grow within the pooled income trust to keep being added to, so that they have that money to pay for the taxes. That's one of their big expenses, is somebody who lives in the community. So if that is seen by the Department of Social Services or by HRA as an uncompensated transfer, we're going to have people who are constantly eligible and ineligible and eligible and ineligible, and we're on one of those merry-go-rounds again. So this is something that you should stay tuned for us to talk more about, to get more clarity about, to see how people are going to be able to continue to use their income and stay in the community and have Medicaid cover for the cost of their care. Because while you might have what Medicaid considers to be excess income, that doesn't mean that you have income to spare after paying all your other bills. And it also certainly doesn't mean that you have the ability to pay $25, sometimes more, sometimes less, but let's average it at $25 an hour for a home care attendant to come to your home and assist you with your personal care needs. And if you can't afford that kind of care, that's what the Medicaid program is here for. Jessica, I see there's another question.
Yes.
Okay, so I'll read that out. Our home and bank accounts are in revocable trusts, which was completed by our firm a few years ago. Thank you for coming to us. Including 2 rental homes. Okay. Okay, so the question is, what do we need to protect ourselves in case we need Medicare? So I'm going to take this person's example, and I'm just going to simplify it a little for the sake of the example, but I think that you'll get the point for your question. So the question asks about Medicare. I want to point out, we're talking about Medicaid. Medicare is going to be your health insurance when you turn 65. I'm sure you just mistyped on this one. Because this person says they're 74, so they likely already have Medicare as their health insurance. Medicaid is a layer of insurance that goes on top of Medicare, or beneath it. It is the payer of last resort. It sweeps along the bottom and it pays for the services that your other insurances don't cover. If your assets are in revocable trusts, then you do not have any protection for Medicaid purposes on those assets, because you have too much control over those assets. You can take all the money, you can liquidate the properties, you could do whatever you want with it. And therefore Medicaid says, great, if you can do whatever you want with those properties, well, then liquidate them and pay for the cost of your care. In order to be protected for Medicaid asset protection purposes, you would take your accounts and take your assets from the revocable trust and put them into an irrevocable trust. Now, that doesn't mean that everyone should do this. You know, this is an informational seminar for the purpose of educating you on the changes in the laws. Someone like this individual who wrote in, you're really going to want to talk to an attorney individually about your situation to see, is Medicaid even a viable option for us? Maybe the income is incredibly too high where it doesn't make much sense, or perhaps there's another reason why this isn't the proper program for you. So not everybody's goal is to qualify for Medicaid, but if you are looking to qualify for Medicaid, a revocable trust is not going to give you any of that protection layer around your assets.
And just to clarify, Britt, also owning anything in an LLC does not protect you from Medicaid as well.
Correct. Owning an LLC does not. You're going to need to create an irrevocable trust, a Medicaid qualifying trust. But there are a lot of ways around that. But again, you just have to make sure it's going to be the right solution for you. Are there any other questions at this point? Oh, can I take money that sits in my pool trust to give gifts? You cannot. A pool trust is a type of supplemental needs trust, which means it can only be used for the benefit of the individual for whom the trust was created. So if you put your excess income in the pool trust every month, you then have to use that for your own benefit. And I've had clients where that's the hardest part of all of this. You know, someone who isn't used to spending on themselves, is only used to giving to others. And I say to them, okay, well, now you have to use your money on you. So you need a new couch. I'll never forget, I was in a client's home and she was elderly and I had trouble getting off of her couch. And I thought to myself, well, if it's difficult for me to get up, maybe it's difficult for you to get up. Maybe you can help yourself and get a new couch now with the assets in that pool trust. You can use it for repairs around your home. You can use it for anything that's for your benefit. If you want to buy a train ticket or a plane ticket to visit a family member somewhere or go somewhere, you can do that as well. It's anything for the benefit of that individual. If you're on Medicaid, you're not supposed to be giving gifts. However, there is an ability for you to use your bank accounts that you keep in your name in a limited fashion. Although once we put a look back on home care Medicaid, I wouldn't advise to give gifts from that account as well either. Are there any other questions? Okay.
Yes, Britt, there's another question.
Yes.
We have someone asking you to reiterate what happens in 2.5 years that is a change.
Yes. So basically, the change in law is happening now. As of October 1, there will be a penalty assessed if you make transfers of your assets after that time. The time period that the law says is the new look back for home care Medicaid is 2.5 years. So when the question is posed, what happens 2.5 years from now? The answer is that this look back will be fully phased in at that time. Until that time, June 2023, that look back won't be the full 30 months, the full 2.5 years. It will only look back as far as it is to get to October 1. But once we pass June 2023 and we pass that 30 months, we will be in a position where it will just be a moving target of a full 2.5 years from when you're applying for the services. So the act fast, and the thing that you need to do now if you're looking for care within the next 2.5 years is transfer assets that you may have been waiting to do or part of your plan that you haven't fully gone through with yet. So really, October 1st is the deadline, but as we sit here on August 20th, I would urge you to speak with an attorney sooner rather than later to make sure that you're on the right path to get any planning that you need done before that time completed in enough time to deal with it. Especially given that during COVID, things are a little bit slower. Something you want to make sure is in the works if it is what you're looking to do as part of your plan.
So Britt, someone now could start an irrevocable trust and transfer their assets into it and not apply for Medicaid right away.
Correct. You could transfer your assets now and then apply for Medicaid in 6 months. And because those transfers were done before the October 1, 2020 date, there will be no penalty assessed for the fact that you made those transfers. But again, you have to feel comfortable that this is the plan that you've come through with. So that's why really step one is getting in and speaking with an elder law attorney who understands the changes in the laws and understands, what it's going to look like when you apply, so you can make sure that you're protecting yourself and your loved ones to the best of your ability.
Britt, can you explain a little bit about how an irrevocable trust works?
Sure. An irrevocable trust, there are many types of irrevocable trusts, but when I refer to one in this context, I'm talking about a Medicaid qualifying trust. It's also what we call a grantor trust. So if I'm the creator of the trust, I'm the grantor. And by it being a grantor trust, that means that all of the income generated by that trust can go to me and I can report it on my tax returns. So it makes tax reporting much easier. than if you're transferring assets to a different kind of trust where you don't retain those certain rights that allow you to report the income yourself. So I'll give an example. If I have that same person with the $100,000 in investment assets, and I take the irrevocable trust, I create one, I say I get all the income, but I cannot have access to principal. That's the key here. I can't have access to principal because if I have access to principal, Medicaid's gonna want me to spend it on myself. So I wanna take that $100,000, I wanna put it in the trust, and I wanna save it to pass on to my children. But I can't use it. I'm gonna say that over and over again, I can't use it. So if you take that $100,000, you take the brokerage account and you retitle it in the name of the trust that you've created, you receive all the interest and dividends from that trust account because you are entitled to that income. You report it on your personal tax returns. But that asset is now not considered yours. That $100,000 isn't considered yours when Medicaid is determining if you are eligible for services. And transferring from you into that trust is what we're saying is going, an example of what will be subject to this look back. So if I take $100,000 and I divide that by the factor, and I'm gonna do the math right here on my calculator, I take $100,000, let's say I'm in New York City, I divide that by 12,844. Well, that's creating an almost 8-month penalty period. So that would be 8 months that Medicaid is not going to pay for the cost of my care because I transferred that $100,000. So what we're saying is that if you transfer that $100,000 before October 1, Medicaid will not see that as a transfer that will disqualify you for any period of time for that 8 months. And so getting it done in advance of October gets rid of that entire penalty period.
Britt, another question that goes along with that. Someone asked about tax implications for transfers to a trust or gifts made before October 1st.
Sure, I'll say two things about gift taxes. One is that when you transfer to this type of trust, because it's a grantor trust where you're retaining the right to income, it's not a completed gift until the time of your death, so it's not subject to a gift tax transfer. So you don't have to worry about gift taxes in that respect. If you were to take that same $100,000 and transfer it to your daughter, for example, that might contain a partially taxable gift. What does that mean? Well, New York State doesn't have gift taxes, so we don't have to worry there. The federal government says that you're allowed to transfer $15,000 a year per beneficiary tax-free. So if I'm a married individual, my spouse and I can give $30,000 to our daughter. If I'm a single person, I can give $15,000 to my daughter. And if I have 5 daughters, I can give $15,000 to each of them. If I then transfer, instead of $15,000, if I transfer the full $100,000, the first 15 is not taxable. The $85,000 balance is a taxable gift, which just means I have to file a gift tax return when I file my taxes next year. But it will not create a tax that has to be paid because a gift tax return is a placeholder against an individual's lifetime exemption. The lifetime exemption right now is $11.58 million. So I would have to give a lot of little gifts to get to 11.58 million before there's going to be a tax. So the federal gift tax is almost a bit of a red herring in that there isn't usually a tax that's associated unless you're giving big money. And I'll be honest, our clients who we're doing planning for that are planning around estate taxes because they have more than $11.5 million don't tend to be the clients that are applying for Medicaid because those with that level of assets aren't applying for Medicaid. They're receiving care through other avenues. Are there any other questions?
Fred, I know that we talked about this major change of the look back, but what are some of the other important changes?
Sure. So the other really big change is going to be to the way that those individuals that do qualify for Medicaid are assessed for services. So once you are financially determined to be eligible for Medicaid, then you have a nursing assessment that determines how many hours of care and what services Medicaid is going to provide to you. What's your plan of care? One of the things that has changed is that the assessment tool that is used to determine the number of hours is going to be uniform across the board, which I think actually might be a good thing. However, it has not yet been created. So they say there's an evidence-based task assessment tool that will be created to determine the level of care that somebody will receive, but that actual tool wasn't created by the rule or the law that was changed. It was stated in that law that it will be created, and so we're still waiting to see that. We have seen some proposed personal care regulations come out about different levels of assessments that will happen, particularly those who need more than 12 hours a day, we believe are going to need an additional level of assessment done by a panel of doctors. Our concern is that there's going to be some delay in getting the care in place with all these new assessments and the look back to look at. But we're going to have to wait and see what actually comes into play in terms of the care assessments and how they are created.
We have another question. Can I put my IRAs into the pooled trust?
Good question. So your IRA is your retirement asset, your 401k, your 403b, your 457, your SEP, I'll keep going, all of these types of retirement accounts. You can keep them in your individual name. So Medicaid says you're allowed $15,750 in assets plus your retirement accounts. So if you have a $200,000 IRA, you're allowed to have that as long as it's in what Medicaid calls payout status. In New York City, payout status means you're taking your required minimum distributions, so you're creating a stream of income. On Long Island, payout status means that you're taking distributions on Medicaid's life expectancy chart, which accelerates your death basically, and makes it that larger payments than your required minimum distributions have to come out. So more than what the IRS requires. But as long as you're taking this as income, you have a protected asset that no one can touch, and it will go to your designated beneficiary at your death. However, the payments that are coming in every month as your distribution, your payout distribution, that is another piece of income that will be added to your Social Security, your pension, your interest, your dividends, whatever income you have. This is another piece of income that gets added into the pot. And then, yes, the excess above the $895 will go to your pooled income trust and be used to pay your bills. Any other questions? I think that might be it, Jessica.
Yeah, I don't have any other questions. Anyone have any last minute questions?
Thank you everyone for joining us. This has been a work in progress, these rules, and we're continuing to watch as they change. If anything drastic happens, we will be putting out as much as we can brief articles on our e-blast list or posting where we can. And if there are updates that we think warrant another webinar, we're happy to do one. If you're not already on our list for emails, you may want to get on there because we will continue to update about this and other topics. And you can always go to our website as well. Thank you so much. Thank you, Jessica. And I hope that you all have a great rest of the summer. It's almost coming to a close now.